Thank you, Madam Chair. As many of you know, at this point, having read the article in the Providence Journal, I would be voting no to this legislation. But before giving my reasons why, I too want to thank, I want to go a little higher with this one. I want to thank first the Senate President and the Majority Leader for allowing this bill to be vetted without interruption, without distraction, and allow everybody to be able to speak their piece, speak their mind, and vote their conscience on this case. I think that philosophy went down and fell down to the chairwoman herself. And we discussed today, interestingly today, that she and I had never, we sit side by side, and she and I had never discussed the merits of this bill until today, and until we knew that we were tentatively on opposite sides of the vote, so to speak. And so I think, and I want to thank all the participants that have been here every single day, looking and watching and listening on both sides of the fence, that have really conducted themselves with dignity, respect, and integrity on both sides. And other than a few stare downs and every once in a while, we've had a pretty successful campaign throughout this. So it really has been a wonderful vetting process, a wonderful debate, and I think it should culminate in something like this where we just bring it down for consideration. With that being said, I want you to know that at least this senator has read everything that was given to him, everything that was emailed to him, every phone call that he received, and with some regret, I read Roe versus Wade about 6 times this weekend. And I had not read Roe versus Wade since 1986 when I was in law school. But I read it 6 times to see what they meant. And with all due respect to my colleagues who are the sponsors of this bill, I will be voting no with some of my colleagues. And there for 3 basic reasons that I have that I will be voting no. In no order of importance, I look to what I called myself the urgency issue. And that is this genuine fear that President Trump will replace another departing justice on the Supreme Court with a conservative whose first immediate agenda will be to overturn Roe versus Wade. And respectfully, I just can't accept that reactionary tale being told by the proponents of this bill. As always, the U.S. Supreme Court needs a case or controversy before it. It just can't overturn Roe in a vacuum. It takes time, quite a bit of time, in fact. Even assuming that there is this case in Alabama or elsewhere, wherever it is, that case has to be briefed, has to be argued, and ultimately ruled upon by the Supreme Court. And that will take even more time. So the pressing need to do this today in reaction to what is a possibility now seems to me to be misapplied. I fully realize that folks that don't agree with me may say, well, he's a pro-life Democrat and he'll utilize any argument for the sake of moving forward. Well, I disagree with that supposition first and foremost, because whatever we do today, ladies and gentlemen, Roe versus Wade is the law of the land. It still is the law of the land until and unless it is overturned. It has been the law of the land for 47 years. And until its actual overturning by a Supreme Court, it will remain the law of the land into the indefinite future. So I say to you, the certitude of it getting overturned after 50 years of jurisprudence, I think is equally speculative at this point. At least my study of law in the 30 years that I've been a lawyer suggests to me that the concept of precedent and the concept of stare decisis is an incredibly strong argument against Roe being overturned. However, I want to assume, for the sake of this argument tonight, that there is an imminent prospect that Roe may be overturned. let's assume that. So my next point is to determine, okay, should I or should I not support this legislation? And does it represent a codification of Roe v. Wade, as we've been told, or is it something more than a codification of Roe v. Wade? To me, I think whether there are backroom abortions or abortion doctors being criminalized and all of those things that Roe was intended to protect against is not part of this debate. To me, I think the heart of this debate tonight is, if Roe gets overturned, does this legislation become a codification of Roe versus Wade? So the first and necessary part of any legal analysis, in my opinion, is to read what Roe v. Wade said. So I read Roe v. Wade, and I read it again, and I read it a third time. And on Sunday afternoon, on Mother's Day, I read Roe v. Wade again, and I read it one more time before I came here tonight. So we know, without belaboring the point, that Roe v. Wade dealt with three groups of plaintiffs in that case. There was a pregnant single woman, there was a licensed physician, and there was a childless married couple. There was a 100-year-old Texas statute that blanketly prosecuted anyone that had an abortion except in the case of the life of the mother. Now you gotta understand that those of us that went to law school knew that there was this growing jurisprudence of cases from like 1965 to 1973 that talked about this right to privacy. Many had argued years before that there was no such thing as a right to privacy because it's not stated in the Constitution. You can't look in the Constitution and find the word privacy as a fundamental right. But cases started to come up on various state laws that talked about privacy in the bedroom, privacy with criminal laws involving sodomy, and all of those things. And ultimately, the Supreme Court, like they did in Roe v. Wade, said, well, the liberty provisions in the 9th Amendment and the 14th, particularly the 14th Amendment, suggest that the right to privacy includes and is embedded within that protection in the 14th Amendment. And personal privacy, personal liberty, includes a woman's right to privacy in making a decision to terminate a pregnancy. But Roe did not stop there, ladies and gentlemen. Roe said, however, they made it very clear that there comes a time when that right to privacy is not absolute. There comes a time when the state has a vested interest, a compelling interest, to be involved and to protect life so that it cannot erode any thought, so it erodes, rather, any thought that this is an absolute right. It is not an absolute right. So if you read on in Roe, and without boring you with the details, they talk about, well, where do we draw the line? And they draw the line seemingly at the point of viability. And they debate, much like we're debating tonight, what different people think. And so they debated viability, and they say, well, sometime after viability, the state has a vested, compelling, underline that word, emphasis added on that word, compelling state interest to make sure that there is a preservation of life. So that's what Roe v. Wade said. And so the second and third reasons why I believe, after reading Roe v. Wade, that that this statute goes beyond, and I don't want to say a mere codification of Roe v. Wade, but it goes beyond a codification of Roe v. Wade in two respects. One, it speaks in terms of non-interference in reproductive health care. And it says, neither the state nor any of its agencies or political subdivisions shall restrict an individual from preventing, commencing, continuing, or terminating that individual's pregnancy prior to fetal viability. It then goes on to say, interfere with an individual's person's decision to continue that individual's pregnancy after fetal viability. It then goes on at page 2, and it says, the termination of an individual's pregnancy after fetal viability is expressly prohibited, except when the medical judgment of a physician It's to preserve the life or health of that individual. We do not have anything but the subjective intentions or the subjective decisions of individuals with respect to viability and with respect to health. And while most people will say that it is not, health should be in the judgment of a doctor, I just want to caution everyone that at page 10 of my version of Roe v. Wade, it says, and I quote, and this is from the majority opinion, maternity or additional offspring may force upon the woman a stressful life and future. Psychological harm may be imminent. Mental and physical health may be taxed by childcare. There is also a family already unable, psychologically or otherwise, to care for it. In other cases, as in this one, the additional difficulties of continuing stigma of unwed motherhood may be involved. All these factors the woman and her responsible physician need to consider. So what I'm saying to you is that under this definition of health, that woman in her 8th month of pregnancy, for psychological reasons, can terminate this baby after viability. That is not what Roe says it is. It is not a codification of Roe v. Wade. And lastly, I just want to say that Roe also said at page 11, the pregnant woman cannot be isolated in her privacy. She carries an embryo and later a fetus. If one accepts the medical definitions of a developing young in the human uterus, and they use the Dorland's Illustrated Medical Dictionary, the situation, therefore, is inherently different from marital intimacy, because they were referring to prior privacy cases, or bedroom possession of obscene material, or marriage, or procreation, or education. It is reasonable and appropriate for the state to decide that at some point in time, another interest, that of the potential human life, becomes significantly involved. And for that reason, ladies and gentlemen, I believe that this goes beyond the codification of Roe v. Wade. And for that reason, and that reason alone, and the urgency issue, I cannot support the bill as presented. Thank you.